with open data and what some of those decisions are around what data is released and how the city manages identifying information in general. So we're going to explain what identifying information is and how it's governed. And we'll also describe a little bit about how we've strived to keep privacy at the core of the city's COVID-19 response, since that's obviously something that's been going on for a year now. And then finally, since it's Open Data Week, we'll talk about how privacy and the identifying information law applies to open data. And how, I don't really think that open government and privacy are actually opposites, but they really work well together to build accountability and public trust. So with that, I'll tell you a little bit more about our office. We are a 6-person legal team that's headed by the Chief Privacy Officer. Her name is Laura Negron, and she's a mayoral appointee. We also have 2 fellows this year who we're very excited to have on our team. And we are part of the Office of Counsel to the Mayor, so we report up under them. And our office is tasked with helping agencies comply with the identifying information law and advising on privacy matters across the city. We work with 130 offices and agencies, and this work involves developing privacy strategies, helping with risk management, and creating city policies related to privacy. We also work with the open data team to make sure that privacy is part of the open data plan as well and strategy. A lot of our work actually involves facilitating data sharing across the city. I think there's one of the misconceptions I run into in my work is that data freely flows across New York City and that information one agency has can be easily shared with another. That's not always the case. It certainly makes for kind of a complicated world, but definitely interesting. So there are a lot of laws restricting how information can be shared, and one of our jobs is to facilitate responsible data sharing of identifying information. I think New York City really does understand the value of its own data for purposes related to getting people to connect with city services and that type of thing. And I think data sharing within legal bounds really helps people trust that the city is using their identifying information appropriately. I keep using this term, identifying information, so I'm going to turn it over to my colleague Howard, who is going to explain a little bit more about what identifying information is and how it's governed in New York City.
Thanks, Kahini. So basically, identifying information in the city is governed by the identifying information law, and I'm obviously going to get into what each of those components mean. First, basically sort of a brief definition of the identifying information law, or IL for short, is that it governs the collection, the disclosure or sharing, and the retention or the maintenance of identifying information by city agencies and their contractors or subcontractors. The IL also provides for the creation and distribution of what are called the citywide privacy protocols and policies. And those are sort of, it's a document that sort of that gives agencies a more detailed guidance on how to implement the IL. So the IL became effective in 2018, and as you see, it applies to all city agencies except the ones listed here. That might look like quite a lot, but as Kahini mentioned, there are 130 agencies in New York City, so it's definitely a drop in the bucket compared to which agencies do have to comply with the IL. And agencies, by the way, also includes borough community boards as well. So the IL basically applies to all city agencies except the ones listed here, or if the law itself is preempted by other law. And what that means is, since we're in a federal system, if a state law or federal law sometimes could take precedence over the IL, and there are a lot of state laws and federal laws that deal with different aspects of privacy. So first, I just want to go over a bit about what identifying information actually is. So basically, as it's listed in the law, identifying information is defined as any information obtained by or on behalf of the city. So that's why city agencies are covered, that may be used on its own or with other information to identify or locate an individual. So notice on its own or with other information, because as you might expect, the usual categories of personal information like name, phone number, email address all fall under identifying information, and those can identify people on their own. But other information such as ethnicity, gender, and race, while not specifically identifying individuals by themselves, can better identify people if they're combined with other information. And that list can actually encompass any number of things depending on the context. Like if somebody's in a group and they're the only person wearing glasses, then having glasses in that context would count as identifying information because it would sort of single out that individual. And there's also a further subcategory of identifying information called sensitive identifying information, which is not explicitly listed in the IL, but it's defined in the policies. And that just means what it sounds like, which is to say that not all kinds of identifying information are created equal. Some kinds obviously are much more sensitive and would cause a lot greater harm if disclosed without authorization or in violation of the IL, such as, for example, credit card numbers, bank account numbers, health information. And so that's basically the standard or the difference between sensitive and non-sensitive identifying information that would cause a greater risk of individual harm or health and safety if disclosed in violation of the law. So for those categories of information, the IL requires an explicit data sharing agreement if agencies are going to disclose that information. Okay, next slide, please. So here's just a list of different categories of identifying information. There's a lot of categories, especially in the top box, which is all the categories that are explicitly defined in the IL. The bottom box are additional kinds of identifying information that the CPO herself has designated because the law gives the CPO discretion to designate additional types of identifying information. Just want to point out that, for example, we in our newest version of the CPO policies, which we just released recently, last month, we added a category of taxpayer ID number and some kinds of biometric information. So now that I've given a brief overview of what identifying information is, let's get into the nuts and bolts of the law itself. So as Kahini was saying, it's kind of a myth that the IL actually prevents data sharing between agencies. What it does instead is it provides checks or controls so that it ensures that agencies collect and share data in line with what they're set up to do or their typical agency activities. Basically, kind of the fulcrum of the implementation of the IL is with the agency privacy officer. Each agency has to appoint one. We call them APOs for short, and they're basically the chief decision makers as far as approving whether a collection or sharing of identifying information comports with the IL. And the standard by which they do so is, does this agency collection or sharing contribute to the agency's mission or purpose? And what mission or purpose means is it's sort of self-explanatory. For example, the purpose of DSS, for example, is to provide services for people who need them and benefits. So if any collection or sharing of information contributes in some way to the purported mission or purpose of how the agency, what the agency was established to do, then that would meet the IL standard for approval, and the agency could go ahead and do that. In this way, the philosophy behind the IL is to balance privacy interests, protecting the personal privacy of the individual whose information might be in an agency record, with facilitating city services and allowing agencies to do their job and to help city residents. And there's also a requirement that agencies have to collect or share information if they're required by another law that's not the IL. As I mentioned before, since there are quite a number of state and federal laws pertaining to privacy in all different areas. So if one of those mandates like a collection or sharing or it has an exception or so forth, then the IL might not apply in that case. For example, state or city records retention laws. So once the APO has determined that a collection or sharing contributes to agency mission or purpose, the IL also gives them another option to sort of increase their flexibility, and that is it allows the APO to make a routine designation. And what a routine designation means is that if there's an agency activity that occurs regularly as part of what's called normal agency operations or business, then the APO just has to approve that collection or sharing the first time it occurs, so that each subsequent time they don't have to make the approval each time. And that just sort of streamlines the process a bit. And non-routine approvals would apply to things like one-time projects or special activities that an agency might do, but aren't sort of chronic and don't come up regularly. So just to give a few examples of what I mean by agency purpose or routine collections or disclosures. In terms of collection, say DOT, the Department of Transportation, has an idea to sort of approve handicap permits, And so they send out an application, or they have an application that for any person who thinks they're eligible to fill out. And on that application, you'd have sort of the usual categories of name, address, etc. And the APO would likely approve the collection of something like that as in line with DOT's purpose. But say the form had like a blank for religion, that probably wouldn't contribute to DOT's purpose of providing handicap permits, because DOT's purpose is, among other things, for the safe movement of traffic and pedestrians, and collecting somebody's religion probably doesn't meet that purpose. So as for disclosure, for example, if DYCD, the Department of Youth and Community Development, wanted to implement after-school programs, and it had contracted with vendors, outside vendors, to do so, and for example, it might need to supply the names of students who are going to be joining these after-school programs, or interested in joining, to these contractors. Assuming that these after-school programs are regular activity or routine activity, the APO wouldn't need to approve the disclosure, DYCD's disclosure of these names to the contractors every time, like you get a new enrollment or something like that. So they could just approve that once, and then it would sort of like the sharing of DYCD to their contractors would sort of happen regularly. The APO doesn't need to sort of monitor and personally sign off on each time that happens. So as happens with a lot of laws, there are exceptions to APO approval, and basically there are three main exceptions. The first is what's called exigent circumstances, and that's sort of a shorthand for emergencies. For example, if a detainee or prisoner were to escape from a DOC facility, or if there's a flooding in the city or some kind of explosion, basically emergency situations where there's an imminent or sort of imminent threat to public health or safety, such that going through the usual APO approval method would put public health or safety at risk. So in that case, the APO doesn't need to approve the collection or sharing of data before agencies can sort of coordinate to try to solve the emergency. And the two main other exceptions are if there's an ongoing NYPD criminal investigation, and if for the welfare of minors or legally incompetent individuals. So lastly, the IL also details notification requirements for violations of the IL. That is, if a collection or disclosure by an agency occurs in an unauthorized manner, such as, for example, there hasn't been an APO approval, or somebody sent the wrong names by accident, something like that. And if that happens, as soon as the APO finds out about this violation, they have to report it to the CPO as soon as possible. And in some cases, they may even have to affect or to notify the individuals whose information was disclosed or collected without authorization, if there's, depending on the potential risk of harm to that individual. Okay, next slide, please. So finally, I'd like to talk a bit about the citywide privacy protection policies and protocols. As I mentioned before, this is a document that sort of elaborates and goes into greater detail about the IL requirements and how to comply with them. And it's really a document geared toward a lot toward APOs and sort of third-party vendors, and just sort of provides greater guidance for them to actually implement the base requirements of the IL. And just a few things, just to go over a few points of what it includes besides additional compliance details. The CPO policies do include what are called privacy principles, and they're sort of a guiding creed for agencies to keep in mind when creating policy, not just when they're collecting or sharing a specific piece of information. And they sort of generally address, again, sort of a balance between protecting the privacy of city residents and also allowing agencies to sort of share information under the right circumstances to improve life for city residents. And Kahini will get into those a bit more. The IL or the CPO policies also include more information about how contractors should protect identifying information, and they include a bit about privacy training for city employees, and just more detail about how to handle violations of the IL. And there's sort of a baseline for agency policies as well. So agencies have to meet the minimum standards listed in the policies, but they can go above those standards and have stricter protocols for protecting identifying information. And these policies, we review and update them in a biannual process, so every 2 years. And we just got done with our recent process and update. And you can see the latest version on our website. And we do so because privacy is I mean, it's obviously a really hot topic now because of, and in part of, because of there's a lot of technology that affects data collection and data sharing, and just new things and new situations come up that you know, agencies constantly have to be aware of. So, you know, it's really, you know, useful or even necessary for us to update our guidance so that agencies aren't following outdated sort of policies. And obviously for you know, things like the COVID pandemic obviously affected privacy in all sorts of ways. So that just, you know, big and small issues or things that come up all affect privacy in various ways. So, and turn it back to Kahini.
Great. All right, thanks, Howard. And yeah, I mean, just kind of jumping off of that, you know, Howard mentioned how our offices work kind of changes as the city's privacy and data sharing needs evolve. And of course, COVID was, you know, it wasn't even an evolution. It was like, this is happening right now. So I just wanted to take a moment to talk about some of the work that our office has done to make sure that privacy is part of, you know, baked into the city's COVID response and recovery. So first, you know, these are just some of the projects we've helped out on. The Recovery Data Partnership is one that the Mayor's Office of Data Analytics and Mayor's Office of Policy were working very hard on, and I think it's a really, really cool project. Basically, external partners give the city data to help the city focus its recovery effort, and we were able to give support there as far as the legal agreements went. And yeah, like I said, I just think that's a really innovative idea. We also had a huge hand in COVID-19 testing and contact tracing when it came to privacy guidance. As you might imagine, this is very contact tracing information is highly sensitive health information. But it's, you know, contact tracing is also an extremely important part of making sure that the virus doesn't continue to spread. So we offered guidance there and worked with our partners, the Department of Health and Health and Hospitals Corporation. We also worked closely with several agencies to stand up the legal framework for the Department of Education's Situation Room, which is a command center for school contact tracing and reopening decisions. And part of that work also involved training the Situation Room staff on their responsibility when it came to handling that type of sensitive identifying information. We're an essential advisor on reopening plans for health screening and employee privacy as agencies start bringing people back into the office. Frequently, I mean, obviously the city exists to serve the residents of New York City, but it also is an employer and employs over 300,000 people, I believe. So it has, in that sense, a really big responsibility to its own employees to make sure that their information, any information they might be sharing related to COVID, are just it is kept confidential or is used appropriately as agencies bring the workforce back in. We've also advised agencies on cloud-based tools during this time. You know, there's just a lot of new ways technology is being leveraged for these types of things, including in employee screenings and that type of thing. So we've been giving guidance there. A lot of our work has also been related to data sharing and using city data to support programs to get New Yorkers various services. Two really good examples are the Get Food program and the Get Cool program. Get Food has been a way to distribute food to food insecure New Yorkers during this time. And that was an interagency effort. So basically agencies would kind of identify a pool of people they felt among their clients who might be in particular need of these types of services. And we were able to find a way to share limited information so that the city could kind of target outreach to those populations and get them the help that they needed as soon as possible. Similar for Get Cool. Get Cool was an initiative to distribute air conditioners to New Yorkers who were vulnerable to heat-related illness and fatalities. And of course, during COVID, this was an unusual problem. During a normal summer, you know, there are plenty of people who might succumb to heat illness in the city, but the city often has cooling centers that they can go to. During COVID, that's really not a possibility when people are supposed to be social distancing. So this was a program to try to identify who should receive an air conditioner and contact them as soon as possible, and so that an air conditioner could be provided to them if they were interested. To give you a sense of how quickly this had to scale up, in the normal year, the city Navy distributes about 500 air conditioners, and in a matter of weeks, they had to distribute 75,000. And so that was a massive data sharing effort that we worked on, and that was, certainly one of the important initiatives that we've been helping with. And then finally, the COVID-19 Vaccine Command Center. As vaccines have been rolling out, we've been advising on privacy for all parts of the Vaccine Command Center. That can be everything from the data analytics work that's being done to kind of better understand where the city's vaccine operations can be improved, to how we can responsibly share data with community-based organizations who might be helping the city with maybe scheduling vaccine appointments or contacting people about when they qualify for a vaccine and that type of thing. So overall, I'm sharing all of this because New Yorkers need to know that their information is being protected during this time, even as the city is leveraging its data to connect them to various services and just supporting its own recovery. All right, but the regular work continues, even though we're in this unusual circumstance this year. So I want to make sure we spend some time talking about that, especially because it is Open Data Week, and we wanted to discuss how identifying information is handled, but specifically in open data set. You may know that the open data law, like the identifying information law, is a local New York City law, which means that they do affect each other and kind of have to play together. So let's talk about how the identifying information law could affect a proposed data set that maybe an agency wants to release on the open data portal. So first, the agency privacy officer would work with that agency's open data coordinator and as well as that agency's legal counsel to identify whether any law would prohibit disclosing identifying information in that data set right off the bat. So as Howard mentioned, there are other laws, state and federal laws, that might prohibit sharing information publicly. As an example, let's say we're talking about a data set from the Department of Education and they want to share identifying information that has been pulled from student records. There is a federal law called FERPA that really restricts the type of information that can be shared from a student record and the circumstances it can be shared under. So that's probably already going to stop some amount of information sharing there. So that could be an example of a time when some other law besides the identifying information law comes into play. Now, assuming that there is no law prohibiting disclosure of that information, the next question is whether FOIL exemption applies. FOIL is New York State's Freedom of Information law, and it allows members of the public to access government records, but FOIL has its own exemptions. One of them actually is unwarranted invasion of personal privacy. So if some kind of FOIL exemption applies to that data, the agency can choose to withhold the information and not publish it. It doesn't have to do that, but it can. So if a FOIL exemption applies, maybe they choose to withhold that information from the data set. But finally, if no other law precludes disclosure and either the agency decides it wants to disclose information even though a FOIL exemption applies, or the FOIL exemption just doesn't apply in the first place, then we get to the analysis that Howard discussed before, which is that an agency privacy officer would determine whether releasing that identifying information as part of the open data set comports with the agency's mission or purpose. And there can be times when disclosing that information maybe doesn't comport with the agency's mission or purpose, but that doesn't mean that's the end of the data set. For example, let's say we had a list of names, addresses, and locations where some kind of fine was issued. You don't necessarily need to say the entire data set is over. The agency privacy officer can and should work with the agency's open data coordinator to figure out a way that maybe the data set could be released with limited information. So maybe it means redacting names and addresses or aggregating information so it becomes more anonymized. For example, if you have a list of people who are receiving a certain type of benefit, rather than listing every person who is receiving that benefit and where they live, maybe you could say, all right, our data set is going to contain the number of individuals receiving that benefit in a given zip code. So there are ways of still making this information public and useful without compromising privacy. And the idea with the system is that it gives agencies the flexibility to make those decisions, and open data coordinators should be part of that conversation, because I think they bring a lot of expertise in terms of data analytics, et cetera, and how that information can be used. And the agency privacy officer can have that conversation with them to ensure that the information is being disclosed appropriately. And finally, now that we've discussed a little bit about our office and its work and the identifying information law, how it applies to open data, I really want to step back and consider during Open Data Week how privacy works with principles of open government. And the list that you see here are the CPO's privacy principles, and I do think they overlap with open government principles quite a bit, especially when it comes to accountability and public trust. Open data lifts the veil off of government work, it empowers decision making, it encourages civic engagement, and these are really great outputs. And I think without privacy, it can be kind of hard to trust the inputs or even the outputs if they violate a city resident's sense of trust in the information that they're sharing with their government. I think privacy is also an equity issue. We want to encourage people to use the city services. And by helping New York City be a responsible data steward, we can ensure that people can participate and take advantage of benefits or services that they're entitled to without having them worry that their information might be compromised in some way. Actually, a good example of that is several years ago, some of you may be familiar with NYC cards, which are identification cards that any New York City resident is entitled to apply for and obtain, regardless of immigration status. And there was a FOIL request that was placed to get all of the application materials related to that people had submitted for NYC cards. And that could have revealed someone's status as being undocumented. That certainly would have had a chilling effect if that information had come out on people choosing to apply for that card and all the associated benefits that come with that card. So fortunately, in that case, a FOIL exemption did apply. It was unwarranted invasion of personal privacy, but that's just an example of how it's really important, I think, for privacy to be a big consideration in what kind of information comes out from government. So if the goal is to be a government that's accountable to and develops trust with its communities, then I think privacy plays a vital role in public disclosure of that information. And with that, that's the end of our presentation, but we would certainly love to take your questions. And actually, normally in the past when I've done this presentation, I've asked people to just kind of tell me, why they're interested in privacy or what brings them to the discussion. So if you'd like to share that, would love to hear it and maybe talk a little bit more.
You have a few questions that are in the chat. Do you want me to read them to you?
Actually, yes, that would be great because I somehow can't see that.
Okay. Are agencies allowed to share biometrics with each other? Are any exemptions? What measures are taken to hold biometric data securely?
Okay. Actually, so normally I would take that myself, but I don't want to put you on the spot. But Becky, are you still on? Okay.
Yes. Hi.
Hi. I don't want, like I said, I don't want to put you on the spot, but are you interested in taking my question?
Sure. I can answer a bit briefly. The answer is that biometric data and biometric information does fall within our definition of identifying information. So most often it is subject to the same privacy protections, excuse me, so the same privacy protections as other identifying information. And as Howard mentioned, there's different sort of classifications. So sometimes biometric information can be considered sensitive information. And additionally, the city is working on developing a specific policy around biometric technology and biometric data. So the city recognizes that there is a particular novelty around this type of information, whether it's privacy sensitivity or security sensitivity. And so we are thinking deliberately about that.
Thanks, Becky. And sorry, Becky is a senior counsel on our team, and I know she's been doing a lot of work related to this, so I just wanted to give her a chance to respond too. But yes, so in addition, as Becky mentioned, the APO process or identifying information law process still applies. So agencies could share information, biometric information with each other, but it would have to comport with the mission or purpose of the agency. As Becky mentioned, because it's sensitive, it would be governed by a data sharing agreement. And also we collaborate with our colleagues over at the Department of Information Technology and Telecommunications to ensure that information is treated, that we're not just disclosing information appropriately, but when it's disclosed, it is handled securely. And they have their own set of security standards that they set for the entire city of New York. And so, we ensure that or strive to make sure that that information is protected accordingly.
We have another question in the chat about whether appointed or chartered advisory boards, I guess, count as agencies under the IO.
No, I don't think that they do. Alex, correct me if I'm wrong. I think you're here too, but no, I don't believe they do.
There is another question from a librarian that helps. I'm a librarian that helps student researchers locate data sets that they can use for dissertation and other projects. So this would be open to all of the MOIP staffers. MOIP, how do you pronounce your office name?
MOIP, yeah.
MOIP.
Some days we're MOIP, but mostly it's MOIP, yeah.
All right, so this would be for all the MOIPs out there. What are your data sets that you find interesting that you've worked on that would be good for students to dive into? Things that have had some interesting challenges that you've had to, my question would be like, interesting challenges that you've had to deal with on the back end that then provide or present interesting opportunities for researchers to kind of dig into?
That is an interesting question. I don't know that there's anything. I think that really just depends on the what kind of research you're interested in doing in the data set itself. I don't know that anything on the back end would necessarily make a data set more interesting on the front end, if that makes sense. Yeah, so I guess I'd just be more curious about like what kind of research they're doing. I almost want to turn it over to Zachary to talk about like just the types of data sets that are available in the portal generally. But I will say that some of the more interesting conversations I've had with agencies about open data sets have been, particularly as technology evolves. I think the opportunity to re-identify people becomes a little more nuanced, I suppose, or just yeah. So we've had some interesting conversations about summonses actually related to different violations, and some of that information is available on open data, and to what extent information that generally public is like made even more public by the fact that it's so easily accessible on open data, and like so those kinds of conversations to me are very interesting because they start getting more philosophical.
Yeah, so I'm happy to recommend some data sets in general, but yeah, I would be really interested in hearing more about what the particular challenges they're running into and what specific data sets they're working with are. We do have a help desk that people can write into and have either us respond as part of the city's open data team or the city agency that's responsible for that data set. So if there is a challenge that someone has where they're not finding something in the data set, we could point them in the right direction. But if there's also a data set that they're not seeing, they can formally request it, and if it exists, they will get a formal response from the agency that either owns it, or in the case it doesn't exist, they'll be able to know that this is not something that the city has.
Yeah, I agree, and that's a conversation we'd be happy to participate in too.
I would say in general, depending on, I'm not sure what level of students these are, if these are high school students or college students or post-grad, but hearing about what like neighborhood data is always something that people find a lot of interest in. I know BetaNYC has been teaching a really great class on Open Data 101, looking at the city's 3-on-1 data centrally. So that's always a good starting point that people are familiar with, and also is something that really pertains directly to their neighborhoods. But I think if you'd share like a few topics, or there's a specific data set that you have a question about, happy to talk more there.
Okay, so I see we have a question saying what safeguard practices are in place if there is a leak of sensitive PII? Yeah, that's a great question. So Howard kind of touched on this at the outset, but there is a reporting process in place. So agencies, if sensitive information is disclosed without authorization, or any identifying information is disclosed without authorization, they are to report it to our office right away. In addition, we have sort of a collaboration setup and process in place with other legal departments across the city. That includes New York City Cyber Command. I mentioned the Department of IT and Telecommunications, as well as Corporation Counsel, or New York City's law department. And members of those teams will coordinate to make sure that the proper notifications go out. And of course, we work with the affected agencies, council, and any program staff there as well. to make sure that proper notifications go out, any steps that need to be taken as far as security goes are addressed, and to really assess the situation and determine where to go from there.
Right, and again, depending on the sensitivity of the information, we might need to notify the individuals whose information has been disclosed without authorization as well.
Yeah, so that's definitely true under the identifying information law, but other laws may be triggered as well, which is, like, for example, I was mentioning FERPA earlier. So if something like that were to happen, there might be notification requirements that those laws have on top of the identifying information law. So just a bunch of things to sort through when something like that comes up. Any other burning questions or just things you're interested in discussing during this time? Okay. I mean, I'm happy to stick around for a few minutes if anyone, would like to sit around and discuss a bit more after, but I think that concludes our presentation and Q&A portion. So just thank you again for joining us. We're really glad that you're interested in our work, and hope to see you again in future Open Data Week, maybe in person next time.
Yeah, thanks to everyone for joining.